Aye. Good morning. This is Friday, March 25th, 1 week from April 1st. Whatever that means, but it is. And we're taking up page 533, a simple little bill, converting civil forfeiture of property and drug-related prosecutions into criminal process. And Ben is going to explain this simple little bill to us. That's 31 pages long. I hope you can do your best.
Me too. Ben Novogrowski from the Office of Legislative Counsel. And thank you, Senator Sears. Yes, I was actually going to ask to, I can do sort of a broad overview of the bill, or really get into, really go through it section by section.
I prefer a broad overview at this point, and then if witnesses wish, we'll get into some of the details.
Okay. So as you said, this is the as passed by the House version of H 533, which is an act relating to converting civil forfeiture of property and drug prosecutions into a criminal process. H 533 attempts to streamline the court process for property seized and forfeited in drug-related prosecutions. Currently, such property is subject to a civil court process governed by 18 VSA Chapter 4, Subchapter 2, that plays out separately from the criminal prosecution of the underlying drug crime. This bill would combine the forfeiture proceeding with the criminal prosecution so that they are heard under one docket number in criminal court. Within that single criminal docket, the bill either creates or clarifies procedures concerning the type of property that can be seized, how property is seized and preserved for evidence, how notice is provided to defendants, owners, co-owners, and regular users of property that is seized and subject to forfeiture. It outlines hearings for defendants, owners, co-owners, and regular users to seek return of the property after it's seized, and it refines procedures for how property can be forfeited and how any proceeds can be distributed after sale. It also places some restrictions on the concept of federal adoption, which I'll get into a bit more in a bit. And the language of the bill is also aimed to give the criminal division as much discretion and flexibility to conduct these hearings and procedures within certain defined boundaries. Before I get into some more detail of the bill, it's important to understand the difference between seizure and forfeiture. Seizure is when the state takes possession of property. This can occur when property is taken during a police investigation, like during a roadside stop of a vehicle. Forfeiture occurs when the state takes title to property that is seized. Put another way, forfeiture is when the state becomes the owner of the property. And I can get into the details of each section now. That was a very broad overview. And I can either share my screen and kind of go in depth more, or if the committee wanted to take a bit more testimony.
I'd like to go over it section by section.
Okay.
But not reading every word. So.
I will my best to summarize. So I'll share my screen now so that the witnesses can follow along in addition to the committee. So section 1 of the bill amends section 32 of Title 4. This is the jurisdiction of the criminal division. Currently in this section, the criminal division has the ability to hear forfeiture proceedings as a civil action. What this amendment does is create the jurisdiction to hear drug forfeiture proceedings as part of prosecutions, or as part of its jurisdiction to hear prosecutions for felonies and misdemeanors.
Okay.
Yeah.
Is the criminal division the state criminal division?
It's the criminal division of the Superior Court.
Of the Superior Court.
Yeah. Section 2, and that is Section 1 of the bill. And as you'll see, there are just some stylistic and renumbering amendments in Section 1 as a result of the change in jurisdiction. Section 2 is really the heart of the bill, which changes the process and procedures in Subchapter 2 of Chapter 84 of Title 18. It starts with amendments to Section 4241, which concerns the scope of property that's subject to forfeiture in these proceedings. So what this does is it adds a new subdivision or subsection C, which creates a series of exemptions of property that is not subject to forfeiture and seizure as well. These 4 exemptions are homestead real property, so it's supposed to be people's homes, U.S. currency totaling $200 or less, a motor vehicle of $2,000 or less in market value, and also stolen property and contraband. Stolen property is supposed to be returned to the rightful owner. Contraband shall be disposed of according to applicable law. And then the criminal division of the Superior Court is also allowed to impose reasonable conditions, including the use of photographic evidence to protect access to property subject to the subsection and its use in later proceedings. And that's really to help preserve it as evidence if it's needed for the law enforcement and prosecution's investigation. And that language may impose reasonable conditions is derived from Rule 41 of the Rules of Criminal Procedure to give it some consistency. And that was done in consultation with the Department of State's Attorneys and sheriffs to make sure that that was consistent.
Then, can I ask you about the homestead real property?
Yes.
So are we talking about, say, somebody who's been using a house as a drug market operation? My understanding of this sort of seizure and forfeiture was that they had forfeited the house because it was being used as the locus for the criminal activity. Is this a reform meant to protect people who are having their homes seized for things that are, you know, trifling, or what's the genesis behind changing it so that homestead property can't be seized?
Well, a lot of the discussion that was had before in the House was that it's really to avoid, you know, people's primary residences from being seized and sort of having corollary effects on their family. So if there are other, you know, their children, their spouses, their partners, other people that live there, it's so that I think that they don't have to live with the, you know, ill effects of the seizure.
So is the definition here, 27 VSA Chapter 3, does that define it as your primary residence?
Yeah, it's primary residence and it's up to a certain value. And so, you know, and I'd have to do a little bit more research about how this plays out in reality. But it is, the homestead real property is defined, it would be the primary residence up to, I believe it's $125,000 in value for the property.
So if it was not somebody's primary residence, they were using it to sell narcotics or whatever, you could still seize it, it wouldn't be captured.
Yes, that's the
So some bar where narcotics are being sold in the back room or whatever is happening, that would not come, that would be forfeitable.
correct. This is only really aimed to,
Protect the house.
the home of someone.
So,
Question also.
$125,000, you can't have a house for that anymore. I mean, you can't have a little
A garage.
8-foot mobile home on it. So shouldn't we, that means that it can be seized if it's over $125,000 value.
Well, I think, again, I need to look a little bit more into this as far as how this would work out. You know, as far as the value limitation, and then if a property exceeds that value, how that would go.
Why don't we listen to the witnesses on this issue?
Okay, got it. Sorry about that.
And I must say too, you know, this language could be tweaked to just say an individual's primary residence or something to that effect, to clarify that further. can proceed if the.
Oh, I don't know why.
And then subsection D is also added to say that the Attorney General's office will advise on the publications that law enforcement agencies can use to establish the market value of a vehicle. And that way there's some clarity about what actually is $2,000 or not. Section 4242 is amended really to outline the process to seize property itself. Outside of some stylistic and renumbering updates, section 4242 remains largely unchanged, which was and still is essentially like obtaining a search warrant to seize property. But it is different. Law enforcement under this section must make a showing of probable cause to seize or secure the property for the court to issue an order to seize the property unless an exemption applies. Those exceptions are when the seizure is incident to an arrest with probable cause or search under a valid search warrant. The seized property is already subject to a forfeiture judgment, or the seizure is incident to a valid warrantless search, like if there's an emergency situation or there's danger that the property may be destroyed or lost. There's also the addition of new subsection C, which is added to help account for the practical realities of seizing property during a police investigation. It does this by permitting law enforcement to secure the property while it applies for a court order to seize it. So it allows law enforcement to gather evidence that it may need, but requires it to apply for the court order to bookend the seizure. And further, what is redesignated now as subsection B would now require the state to apply for a court order for property seized under one of the exemptions when it pursues forfeiture of the property. So again, it's to kind of close out that process to ensure that there is an order verifying the seizure. And the rest are really just renumbering and redesignations. Section 4240A is a new addition for prompt post-seizure proceedings. So under this new section, a defendant, co-owner, owner, or regular user of the property has a right to a hearing to determine if seized property should be returned. For context, those terms of defendant, owner, co-owner, regular user is language that's currently used under the law and is meant to account for all individuals that might have an interest in the property or may depend on its use, like relatives or friends that regularly use the property but may not be owners or interest holders in it. Under this new section, the state must notify these people if they are aware of them after a reasonable search of public records that the property was seized. After notice and a petition by the individual, the court must schedule a prompt hearing and it has the discretion to schedule it alongside other hearings in the case. The hearing may be extended upon motion showing good cause, which can be supported by a sworn statement or by an agreement of the parties. After the prompt post-seizure hearing, the property is returned to those people if the court finds that the initial seizure was either invalid, that no criminal charge is filed and there's no extension granted by the court to file a charge. The property is not needed as evidence in the underlying case, or the outcome of the underlying case is likely to be in favor of the defendant or someone else with an interest in property. The process would not apply to contraband. And this concept of a post-seizure hearing is really aimed to provide due process to those that are aggrieved by a seizure. This is derived from this concept that was elucidated in this Crimstock case. It was a Second Circuit case written by Justice Sotomayor, who was basically explaining the due process concerns about what seizure does. But before there's the forfeiture hearing itself, there's that gap between seizure and forfeiture. And a lot of times people are aggrieved. There was a bunch of examples in that case of people that had been arrested for DUI. Their cars were seized and the forfeiture hearings were delayed and there was no ability for them to get the property, their vehicle back. And so their ability to go to work, go to medical appointments was impacted greatly because of just the time it took.
We don't have Judge Zone today, so Peggy, would you make sure that Judge Zone is here for a future meeting on this, so we can hear his thoughts on prompt hearings?
And I have a question about that. So it says that there shall be a prompt post-seizure hearing twice, but then it also says that the owner may petition for a prompt post-seizure hearing. Is that in the event that there's being denied one, but?
Well, yeah, and the intent of the language there is that really it would be scheduled if there was a petition made. But it could be done in either situation. It could be automatic.
Because it seems confused here. It's like both things are going on at once. In other words, on line D or subsection D, the criminal division shall hold a prompt post-seizure hearing. But then up above, it says someone may petition for such a hearing, which makes it sound as like there won't be one unless there's a petition.
Well, and that can be, clarified to be a little bit more consistent. And in that court case, the court didn't get into really what the proper procedures would look like. They just said that they had to exist. And I think it would be a policy decision for the committee to say, do we want this just to be automatically scheduled right out of the gate without the need for a petition, or does the petition itself prompt the hearing?
I would vote for automatic, but that's probably for later on. Because otherwise, people without lawyers or they have no idea.
Okay,
Okay. So scrolling through onto the amendment to section 4243, which is now entitled Criminal Forfeiture Proceeding. 4243 is what truly streamlines the forfeiture process and melds forfeiture into the criminal process. Rather than forfeiture being a separate civil process, this section is amended to incorporate forfeiture as a criminal sanction in an underlying drug prosecution. To achieve this, section 4243A now permits property forfeiture as a criminal sanction in 3 ways. First, property can be forfeited if the defendant is convicted of the underlying drug offense and the state proves that the property is an instrumentality of the crime by clear and convincing evidence, meaning that it's highly probable or reasonably certain that the property was used in the commission of the offense. So what's sort of almost the default here is that the conviction is required first, and the proof that the property was used in the crime. And then you can use forfeiture as a sanction, either along with sentencing, and there'll be some more details about that later, after that conviction occurred.
I'm trying to understand what the point is. To be honest with you, most of the drug deals that I'm aware of occur in, anyway, rented cars. So you can't seize an Avis vehicle, I don't think. Maybe you should be able to, and I would teach Avis to be more careful about who they rent to. But I'm picking on Avis now. I don't, could be any rental car company, but they're number 2. They strive to be number 1. So I'm understand. I don't really understand. I think what I've seen and heard talking to prosecutors and others, most of the vehicles that are used in drug trade are rented. Most of the houses the people are occupying and trading drugs as favors for using that house, and most of the people who have drug addiction problems. I'm not sure what this bill would actually accomplish. So I'm having I hear it's a wonderful bill, but I need to be convinced by folks that are in support of this bill that it does something.
Well, I think that some of the witnesses here today are probably best to speak to the reasons underlying this. However, in the House Judiciary Committee, there was testimony taken and expressing that the intent behind this is really to ensure that there aren't any undue consequences on family members of people. And so, for instance, the rental car situation, the way some of this, the language in this bill is written, and this is really getting into, I think, section, well, it's really the use of owner, co-owner, or regular user. That is aimed to say if it's the family vehicle, if it's someone that's owned. And so I think in the rental car situation, there probably isn't a regular user of a rental car, someone that owns. So those theoretically, depending on the facts of each case, obviously, would be excluded from this. This is really just aimed to.
And other than cash, I don't know what, is what the point is. We already have forfeiture rules, as I understand it. We do.
Right.
I remember writing a bill on it, and
And the other aspect to this as well is right now our forfeiture process is a civil one. So it plays out separately from the criminal process. And I know that the House Judiciary Committee heard testimony saying that oftentimes the civil process is, for lack of a better term, kind of forgotten about, by the defendant. A lot of times that property, there are defaults that are that happens in those civil cases that forfeit that property because.
well, a lot of times what I see is a large amount of drugs and a large amount of cash and firearms. So if we zero in on those three items, which seem to be the most common, I'd like to understand how this changes current law. So
Is the goal of the bill to protect these innocent property owners who are like the family living in the house and not the person selling drugs?
I don't know that they need protection.
Well, I think really the way it's set up, it's to provide the mechanisms to get the property back if it affected them unduly or if the property didn't need to be seized.
But under current law, do they need the protection?
I think the House Judiciary did hear testimony of, sort of in a general sense that there are these issues out there. However, I think that those witnesses who are here are probably better to speak to that than myself.
Yeah, the more I look at this, the more I wonder why we need it.
I mean, there was a case in Rutland whereby an elderly couple owned a house and their son was living there and selling drugs, and that property was seized. I think that's actually a case some years ago, but I think that might be. Anyway, they were of course losing their property, and they didn't have anything to do with it.
Yeah, that's a case where you could easily see this helping preserve their lifestyle, even though their son used their
Right.
residence. I'm wondering if there was any testimony on the other side of this. In other words, when it comes to forfeiture laws, the thing that's disturbed me over the years is that it can, in some situations, and with some law enforcement agencies in some states, seem to incentivize the taking of property.
Right.
So, they see that someone has big assets and they have a drug bust there, and then they, seize everything, and there have been abuses of that sort of system. So I'm wondering, is that what you're thinking?
There is, and that I think you're getting at the federal adoption concept, which is later on in the bill, and law enforcement did have extensive testimony about this, and I think that they can probably speak to it as well.
Senator White.
At the risk of being a Budinsky, maybe we should let Ben walk us through the rest of the bill, because I think the questions that we're asking are not for Ben.
I think it's a great idea.
I'll try to speed up a little bit. So in subdivision 2 of section 4243A, the second instance that forfeiture can occur is if a person enters into a plea agreement or other agreement with the prosecutor, including agreement under which the person is not charged with the offense, subjecting the person to forfeiture under this section. So this is So this language is slightly changed to permit plea agreements while keeping the statute's current language. And then the third instance is under subdivision 3, where a defendant is permitted to agree to forfeiture as part of an immunity agreement, which is when a defendant provides testimony or other assistance to law enforcement in exchange for immunity or reduced punishment. Subsection B establishes that discovery would be pursuant to the rules of criminal procedures. It's now a criminal proceeding. Subsection C establishes that the burden of proof is, and this is unchanged, it's at the clear and convincing evidence standard, which is lower than the reasonable doubt standard that is present in most criminal proceedings. But this is slightly different as far as the forfeiture of the property itself. Subsection D outlines how the defendant is notified of forfeiture as a potential criminal sanction. The notice, so the notice must occur when the state decides to seek forfeiture of property and must be its own document, but it can be included with other documents like the criminal information when a charge is formally filed, or with the notice of potential collateral consequences. The notice can occur at an arraignment or sometime afterwards, but not later than 30 days prior to trial, unless the court decides otherwise. The notice must outline the underlying facts of the case, the time, date, place of the seizure, the names of any owners or any interest holders of the property, the current location and custodian of the property, and a warning that the seized property is subject to forfeiture. Additionally, the notice of potential collateral consequences that a defendant receives must include the notification of forfeiture. And that the potential collateral consequence notice is a document that warns a defendant of the consequences of being found guilty of the crime of which they're accused. It's normally provided to the defendant at an arraignment or when they accept a plea agreement. But going back to the notice for proposed forfeiture, it must be properly served on the defendant and any owners or lien holders of the property if they are known or readily ascertained. It must also be published in a newspaper for general circulation as directed by the court. And it's not to be read to the jury in the underlying case. And it may be amended by the state before the trial if necessary. And the court may also grant extensions for the filing of the notice in its discretion. Subsection E requires a law enforcement agency to return property if the notice of potential forfeiture is not properly sent. However, the agency does not need to return contraband evidence or other illegally possessed property if notice is not properly given. This remains largely the same with the deletion of an agency's return of property due to a lack of notice would not, so it was removed that under current law, an agency's return of property due to lack of proper notice would not restrict them to commence a forfeiture proceeding in a later time. This kind of says that you have one shot to do it the right way. Subsection F is just removed, and these are just stylistic changes and for the order of things. But these were removed to comply with the notice procedures that we just went over. Section 4244 establishes various forms of forfeiture hearings. So it would create and govern 3 types of hearings. And this section expands on the one type of civil hearing under current law to clarify who and what procedures are involved in these types of hearings. The first type of hearing is the defendant's forfeiture hearing. This is outlined in subsections A, B, and C. Subsection A explains that the defendant's forfeiture hearing must occur after the defendant is convicted of their underlying drug crime, and the hearing must occur without a jury. The court has discretion to schedule the hearing so that it occurs as soon as possible after conviction, including concurrent with the sentencing hearing. Again, it's aimed to make things a little bit more efficient, but also give the court discretion to schedule it as it sees fit. Subsection B outlines 4 exceptions to the conviction requirements, meaning that the state can gain title to the property without a conviction, but only upon a motion filed within 90 days of seizure and a proper evidentiary showing. In those cases, the state must show by a preponderance of the evidence, meaning that it's more likely than not, that the defendant either passed away, was deported, abandoned the property, or fled the state. Subsection C ensures that the forfeiture of property is proportionate and not unconstitutionally excessive in comparison to the underlying crime. This is to reflect the prohibition against excessive fines established under the 8th Amendment as incorporated against the 14th Amendment of the U.S. Constitution and also Section 39 of Chapter 2 of the Vermont Constitution. Under this subsection, the court has discretion to hold a proportionality hearing at the request of the defendant, a co-owner, an owner, or other regular user of the property. The petition must prove by preponderance of the evidence the forfeiture was unconstitutionally excessive after considering all relevant factors, which may include the seriousness of the underlying crime and the impact on the community, the extent of the defendant's participation in the crime, the extent that the property was used in the crime, and whether the crime was attempted or completed, and any hardship to the defendant or the defendant's family. The second type of hearing allows lien holders to petition the court for return of the property or for compensation for it. To start, a lien holder is an individual or entity that has a security interest in the property, like a bank or an individual that might finance a vehicle.
We're on page 14, correct?
Yes. About halfway down at this point. Under subsection D, a lien holder could petition the court so that the property is not forfeited and can be returned, or at least the value of the property to the extent of their interest is returned. The interest holder must show by clear and convincing evidence that they hold a valid, good faith, and direct interest. So it can't be held through another party or a straw man. And additionally, there must be showing that the lien holder did not have actual knowledge that the property was used in the commission of a crime. And that is defined in the statute of what actual knowledge is. If the lien holder is successful, the property can be returned, or the lien holder can be compensated to the extent of their interest, whichever is of less cost or expense for the court and the process. The third type of hearing is the innocent owner hearing. And this provides a way for owners of property who are truly innocent to get their property back. It is similar to the lien holder hearing in that it allows owners, co-owners, and regular users other than the defendant to petition the court for return of the property, but there is a slight difference. Under subsection E, a petitioner may file a simple written statement with the court outlining their interest, how long the property was acquired, a request for the return of the property, and any other additional relevant facts. The evidentiary burden is the same as it is for the lien holder. However, if the petitioner proves legitimate interest in the property, then the burden flips onto the state to prove that the petitioner isn't innocent, meaning that the owner consented or knew that the property was used in the underlying crime. If the state can't prove that, the property is returned to the owner. The court is also empowered to impose reasonable conditions. This is that Rule 41 language again, to ensure that the property can be preserved in some way to be used as evidence in the underlying prosecution.
So I know we're walking too quickly, but let's say that someone has a child, or first of all, does the person have to be of age to be the innocent party?
Well, they would have to show that they either owned it or used it, and
What I'm saying is that, let's say it's a house.
Right.
And the couple that owns the house has a child. They're engaged in selling drugs. And the house is being used, they both know it's being used as the way to sell the drugs. The child obviously is innocent. Could a petition be filed on behalf of the child to keep the house?
yeah, there's no prohibition to prevent that from this happening.
Okay.
So going on to what is now subsection F. This just outlines the different judgments and sanctions that a court may enter in a forfeiture hearing. So one type is that it can dismiss the forfeiture proceeding outright and return the property to the rightful owner if the state fails to prove its burden in the underlying case. Except in the case of regulated drugs or property that is harmful to the public, those things must be destroyed. The court can order forfeiture of the property if the state proves its case, or the court may accept a stipulation or plea agreement after it holds a hearing. Section 4244A establishes appeal rights for the defendant of these decisions. And then section 4245 it concerns remission or mitigation of forfeiture to the state's attorney. This section allows an owner, co-owner, or person who regularly uses the property other than the defendant to ask the prosecutor to return the property or mitigate the impact of losing it before judgment is rendered by the court. The petitioner must submit a sworn request to the prosecutor, who then must investigate and has the option to interview if necessary. The prosecutor must also approve or reject the request within 30 days. The prosecutor has discretion to approve the request to prevent unjust hardship or upon the finding of the valid and direct interest in the property. Currently, the law permits this type of property loss prevention or mitigation. However, it's managed by the court and not through the prosecutor. The expansion of 4244, the previous section that we went through, and the creation of the lien holder and innocent holder hearings preserves the court's ability to do that, but this section expands it to permit the prosecutor to also use his or her discretion to do this. This is designed to create another mechanism to access the seizure and forfeiture process for those that may be unduly aggrieved by it. This bill also amends section 4247, which you'll find on the top of page 19. This concerns disposition of property that's forfeited. So how, once it's sold, how we distribute the proceeds of the property. The amendment provides clarity to timelines and how property should be distributed, in addition to updating the statute to reflect current changes in the law. First, subsection A provides the state treasurer with the ability to sell forfeited property between 3 months and 1 year after the date it is received by the treasurer's office. There's amendments to the statutory cross-reference to reflect the current law that governs public sale procedures. Subsection B is amended to ensure that proceeds from the sale of the forfeited property are distributed after all appeals are exhausted or upon the decision of the court. It's also amended to ensure that the proceeds can be used to pay restitution to any victim of the underlying drug crime first. And then after initial costs and restitution is paid, the law's amendment to direct the state treasurer to distribute 45% of the remaining proceeds to the Attorney General, the Department of States Attorneys and Sheriffs, and state and local law enforcement based on their proportionate share of or proportionate participation in the underlying investigation and prosecution. The remaining 55% of the proceeds are directed to the general fund. And for context behind some of these changes, the amounts themselves remain unchanged, but who has the discretion to change, to direct these funds does. Previously, it was the governor's Criminal Justice and Substance Abuse Council. That no longer exists. And so the state treasurer was selected as a replacement after research showed that the proceeds are already currently held by the treasurer. So it seemed like a sensible entity to be responsible for them.
All right, great.
So we have one last section.
I know, but that's, go ahead.
And then new section 4248 is the federal adoption section that I alluded to before. It's added to create a limitation on federal adoption. And what federal adoption is, it occurs when a state or local law enforcement agency seizes property under state law and then requests that a federal agency take the seized property and forfeit it under federal law. This new subsection would issue with my screen share.
It's all right.
But so what this would do is that this new subsection would limit when federal adoption can occur only involving U.S. currency exceeding $25,000. So federal adoption could still occur when currency of $25,000 or less is seized. It would only apply to currency included in property seized from people who have an interest, or those who regularly use the property. So there was testimony heard by law enforcement at the house level that sometimes there are situations where, for lack of a better term, drug mules are used who are not regular users or not owners. They would be excluded from this. And so this would only occur when there was an owner or co-owner or regular user involved. And violation of these limitations would prevent state and local law enforcement from accepting any forfeiture proceeds from the US government, and any payments received in violation would be directed back to the state's general fund. Importantly, Section 4248 would have no effect on state and local law enforcement agencies from participating in joint task forces with the US government. So if a state or local law enforcement agency is already partnered with a federal agency, who's already using federal resources and processes to seize property, then the agency is still permitted to do so without limitation. And then finally, Section 3 is the effective date of the bill, and it would go into effect on July 1st, 2022.
Yeah, I just-
Sure.
So kind of all the way through here, we've been thinking primarily, I think, of drug busts but does this apply to any forfeiture for any other reason or just drug?
No, this is only for drug offenses.
So if somebody is operating an illegal dog fighting ring in their basement, this doesn't apply at all?
So that's the one caveat actually, is that so under 13, section, Title 13, Section 364, this is included in that. There's a lot of, it's alluded to in the drug forfeiture statute. So, because I think oftentimes, and this is before my time, but when this was added, I think a lot of times the two are sort of connected. And so this would roll those violations in there, but it would not extend beyond drug forfeiture or animal fighting.
So
Just
anybody,
animal fighting? Wow, great call.
Yeah,
well,
and my apologies.
yeah, okay, I get animal fighting. What if they're operating an illegal, I guess we're not a dry state, so that would be, but something else that, and is property ever seized and forfeited for other, say they're running a counterfeiting money thing in their basement?
That's prostitution.
So, yeah, there are
Yeah, or
other,
it was used prostitution, but, yeah.
there are other forfeits under state law. So there's fish and wildlife related violations, there's liquor forfeiture violations, auto, and the sponsors of the bill, I think initially it was thought of as trying to be as extensive as possible, but I think it was scaled down, and there was some testimony provided to use drug forfeiture and animal forfeiture, since it's kind of part of that statutory construct, to amend the process first under those violations before kind of taking a wholesale approach.
So this really is aimed at that. We don't have any standard forfeiture seizure procedure. It could be different for Fish and Wildlife and DLC.
They do have their own procedures.
Okay. Yeah, thanks.
To what extent, it seems like the phrase regular user of the property is peppered all the way through.
Sure.
To what extent does that already exist, and is there a legal standard for regular user of the property, or does this sort of attempt to create that?
It could be the person that's buying the drugs.
Oh, that's true.
Kind of wonders.
So that term already exists under the
Okay.
current statute, so that's why it was rolled in here. And really, I think that's a fact-specific inquiry over who, in a given case, who is considered a regular user. I can try to do a little bit more research to get a more definitive answer.
But it's the judge's call.
Yeah, that would be my instinct, is that it really depends on the facts of the case. And so, if you have a partner who is not an owner, but uses a vehicle to drive to work every day.
Well, this is my question. Let's say you have a friend who's not related by law
Mhm.
to this person, and that friend stays in a room in the house or uses a vehicle, it just seems odd that we would be saying somebody who's not related, they're not an heir, they're not a child, they have no legal connection to the property, but here, their rights are overcoming a state's right to forfeiture, theoretically, if a judge agrees. And I'm wondering, it seems to bend over a little backwards for people who might be, if not participating, then completely neutral to the process, and yet asserting a right that overcomes all the government's rights there.
Yeah, and under this, they would have a basis to petition the court.
Yeah.
But I think as far as, you know, if that's proper or not, that's, I think, a policy consideration for the committee. But, you know, if the facts warranted that an acquaintance or a friend, you know, could be considered a regular user, then yeah, they at least have a mechanism to petition the court. But that does not.
Hero Kate, the guy who stayed in OJ's guest house.
Oh, yeah.
Yeah.
And
Okay,
But yeah, that I think would be a policy consideration.
I'm kind of anxious to get to some of the witnesses.
Okay.
Bill better, because I have similar questions to the rest of you about this bill, why, what it actually is going to accomplish.
I mean, you know, many years ago, and it was very popular for drugs to be all over the place in a different way than now. I mean, I can picture several houses in my town that had the federal drug poster on the front of them that were seized by the federal government. I mean, it was fairly common to see those. It was like,
Can I just tell you that while we're shifting gears here, that there's a house in Brattleboro that is widely known for drug use, and they did a big bust there. I don't know if it's gone back to it or not, but somebody put a sign in the window that said, if you can't get your drugs here anymore, go to so-and-so. It was
very helpful.
very helpful.
Well, that's a great
Take your
segue
business.
for Evan Needham.
okay,
Evan, sorry for being delayed or getting to witnesses, but this is not as simple as I first thought it was.
Absolutely no apologies needed. Thank you very much for having me this morning. For the record, my name is Evan Meenan, and I'm a deputy state's attorney assigned to the central office of the Department of State's Attorneys. In principle, the department does not have an objection to getting rid of civil forfeitures, which is what we have now in the state, and making drug-related forfeitures part of the underlying criminal case, which is sort of the central shift of this bill. That said, prior to testifying in the House, the department reached out to several states' attorneys, and it appears as though Vermont's existing forfeiture laws are very rarely used. For example, Orange, Windsor, Chittenden, and Washington County all said that they don't use this. They don't use Vermont's existing laws. There's been a few instances where forfeitures have been negotiated as part of a plea agreement. And Windham County said they recalled one use of the state's forfeiture laws in the past 15 years. And that's a very quick summary of the counties that I heard back from. So Vermont's existing forfeiture laws really are just not used to any great degree. That's not to say, however, that property isn't forfeited in Vermont pursuant to federal law, but the state's attorneys don't get involved in that process. So other witnesses would be better suited to answer questions about how the federal forfeiture laws work. The state's attorneys do receive a little bit of money from federal forfeitures, and that money is primarily used for training. But so far, the department's business folks haven't flagged for me any major concerns with this bill. If those concerns are flagged in the future, we'll obviously bring them to the legislature's attention as soon as possible. But for that reason, the department's participation in the discussions of this bill to date have not focused on the provisions related to federal adoptions and limitations on federal adoptions. As legislative counsel sort of hinted at, the department did have some concerns with the bill as originally drafted, but most of those I would not characterize as substantive. Our primary goal was to make sure that if the legislature chooses to move in this direction, we have a law that can be implemented practically, and that it's compatible with Vermont Rule 41F. And that's something that legislative counsel mentioned during the walkthrough. 41F pertains to motions to return property that has been seized by law enforcement, but which either isn't going to be subject to forfeiture or hasn't yet been subject to forfeiture. So we wanted to make sure that any new forfeiture scheme was consistent with that process and that there weren't any conflicts. The department feels like both sets of those concerns were sufficiently addressed in the House Judiciary Committee. So it's very thankful to the work of that committee and also the work of legislative counsel. And right now, the department doesn't have any new issues or concerns that it would like to independently bring to this committee's attention. Obviously, if this bill does result in Vermont's state forfeiture laws being used more frequently, we could identify some issues regarding implementation in the future. And, we'll work with the legislature and other stakeholders to get those ironed out. There were a couple of proposals that were advanced in the House that didn't quite make it into the bill. And if there are any changes to this draft, we would really appreciate the opportunity to come back in and let you know if we have any concerns. But with all of that said, I'd be happy to try and answer any questions. The two that I recall being asked dealt with homesteads and carving out homesteads. Certainly the degree to which primary residence and homesteads should be addressed is, a policy issue that the legislature can resolve. I think the state's primary concern would be not providing any undue protection for the sort of bad landlords, the landlords that know that they're operating what has essentially become a drug house. And, they don't care about addressing the situation so long as the money keeps coming in and it results in some blight into the community. So we would just want to make sure that's on the radar. The other question that I recall being asked had to do with whether or not a post-seizure hearing should be mandatory. And the only sort of thoughts that I would offer for your consideration is, there are situations, and I anticipate law enforcement may talk about some of them later today, where, property that is likely connected to drug activity is seized, but the person that they're seized from either says, I don't know who owns that. I was just asked to bring it, to transport it someplace. And so there may be cases where we know that cash, especially cash, is connected with drug activity, but there is no identified owner, co-owner, or regular user of that cash because people are trying to distance themselves from the criminal activity. So what I would suggest is, does it make sense to require a hearing in situations where we don't have an identified respondent, or even if we do, the person is not contesting forfeiture?
Question for me, Evan? Evan, I have one question regarding the distribution. Obviously, you said there hasn't been much experience under current law, but the distribution of the 45%, the Office of Attorney General, Department of State's Attorney and Sheriffs, and the state and local law enforcement agencies. That's done by the treasurer. How do you determine, if the involvement was the state police, the drug task force unit, which involves local and all that? How does all that get divvied up? And what do you do with the money?
Yeah, that's a great question. And I don't think that it's one that is that has a current answer because state forfeiture laws are so infrequently used. And my recollection is that the existing entity that's supposed to make that determination, the Governor's Criminal Justice and Substance Abuse Council, no longer exists. So there's no one currently making those determinations. I would hope that if the state treasurer is assigned this responsibility, it would go through some sort of process, whether it was rulemaking or promulgating some type of procedure that would take into account the input from these three entities and then make it clear how it's going to make this determination moving forward. In terms of how states' attorneys use the federal forfeiture dollars that it receives, it's primarily for training. So for example, if there's an opportunity to attend an out-of-state training, the department may not necessarily have the money in its own budget that the legislature has appropriated. Maybe there'd be some funds available to send someone to a training like that. But my understanding is that we're not talking about buckets of money here. We don't get quite a lot. And but for the most part, that's what it's used for, to take advantage of training opportunities.
What are the things that are seized now? Mainly?
Well,
Cash, firearms, and the substance, the drug itself, right?
Yeah, that's my understanding. And again, because we're not using the state forfeiture laws and because the state's attorneys don't get involved in the federal forfeitures, the law enforcement witnesses this morning are probably better equipped to answer that question. But I would expect that it's primarily cash and vehicles. However, I think as you pointed out earlier this morning, lots of times these vehicles are rented or they're not worth a lot of money. And sometimes it just simply may not be worth, pursuing a forfeiture. Having conversations with other folks who have been involved in the federal forfeiture process, I do think that residences are occasionally seized. For example, I know of a couple of years ago in Rutland that were seized that were essentially those bad landlord cases. And my understanding is that those homes have since been rehabilitated and turned into some nice residences. I think one person that might be able to answer some questions about how the state is involved in that, aside from law enforcement, might be someone like Chris Loris, the former mayor of Rutland. I think he might have been the mayor when those houses were subject to federal forfeiture.
Right. My recollection is he was, yeah. It was an effort to take a neighborhood and turn that neighborhood around.
And I believe it was successful. However, I haven't been there in a while.
I think former corrections commissioner Jim Baker was chief of police and Chris Loris was the mayor under that effort. Good idea. Any other questions for Evan? Thanks so much for hanging in there.
Thank you very much. I'll be around for the rest of the morning in case there's more questions.
Any changes. The next witness is Marshall Paul, under General, the Deputy Defender General.
Good morning. So thank you, Marshall Paul from the Defender General's office. And I'm going to start out by saying that we do support the direction that this bill goes, because we agree that, we agree with the people who introduced the bill that there are some fundamental problems with Vermont's current forfeiture law, really with regards, to not only sort of what we would see as really constitutional and justice issues, but also in how it's implemented, and it really just not taking into account some of the really important interests of people other than the owners of property, like innocent, co-owners or people who are, regularly using property. However, that said, we have a lot of concerns with the way this bill is drafted and with the way that it's implemented. So I'm going to go through it sort of step by step. And I think the first thing that I will raise is on page 3 in section 2, where it's addressing the exemptions from seizure. And from our perspective, those exemptions are just not, they're not enough. If the idea here is to ensure that what is essentially subsistence assets the assets that people need just to get by, just to get through day-to-day life are not being seized and turned over to the government. We think this isn't enough, that $200 of currency is too low of a number. $200 of currency doesn't get anybody much of anything. And that in particular, a motor vehicle value of $2,000 or less is not really worth anything, because honestly, right now, you cannot buy even a used motor vehicle for $2,000 that can pass inspection. $2,000, if you're going to have a $2,000 exemption, you may as well not have any exemption at all, because there is no usable motor vehicle with a value of $2,000 or less. So we do have concerns about that could be addressed by simply raising those numbers. We also have a concern on page 4. This would be in section 4242. About halfway down, there's a subsection C, which says the state may temporarily secure property pending a request of the state for state ex parte for a preliminary order for a process to initiate forfeiture. We have a concern about that, because what that's really doing is allowing a seizure in a place where seizure is not allowed currently. If you look above that, subsection B, sections 1, 2, and 3, it really explains that property that's otherwise subject to seizure can then be forfeited. But then this additional section, subsection 3, in our opinion, creates a new grounds for seizing property. And we do not want to see this bill be expanding the scope of how the government can go seizing private property. To the extent that what this bill is trying to do is sort of narrow and direct and provide guidance for how the government seizes property, we're okay with that. We don't want to see it being expanded, and that's what that provision would do.
Marshall?
Yes.
Marshall, if I could just ask, I'm not sure I understand how this creates a new justification to seize the property. It seems to me like, if I'm looking at the right place, see, on page 4.
Yes.
It seems like what it's doing is allowing the property to be secured so that someone couldn't come in the middle of the night, drive the car away, or take the cash and suddenly it's gone.
I agree.
So it's
not. I mean, when they take your car and secure it so you can't drive it away, that's a seizure. And if this is allowing them to seize property that they would not have been able to seize before simply because it is forfeitable, because right now there's property that's forfeitable but it's only forfeitable when they can seize it pursuant to some existing exception to the Fourth Amendment or under some existing Fourth Amendment allowance, like a warrant or like an existing exception to the warrant requirement. But the way that we read this, where it says that they may secure property simply because they have a request for preliminary process that's been filed, that would allow them to seize property in places that they currently can't seize it.
Well, it says temporarily secure property, but I guess what I would say is that from my limited understanding and just having approached it today, it sounds like this closes a loophole in existing law in which the property that is legally subject to seizure hasn't been seized yet. And if you can get it out of there somehow, it won't be seized.
I don't think, that's not the way that I read this. The way that I read this is to say that if the government has filed a seizure petition or a forfeiture petition, then they can seize the property to protect it while the forfeiture petition is pending. That's a right they did not have before, and it wasn't viewed as a loophole. It was before, what we said is we said that the only property that would be subject to forfeiture was property that was already subject to seizure because it was contraband that was found during the course of a search, or because it was, otherwise, in some way subject to seizure. This opens it up and says, we're going to allow the government to seize anything they believe is forfeitable up until a court makes a decision as to whether it's forfeitable. So it allows the government to seize property temporarily that under current law, they haven't been able to seize. And honestly, it is not very clearly written. And if other witnesses have a different opinion and believe that this is not actually changing what property is allowed to be seized, then we would want that to be made more clear, because certainly the way we read this, it reads as if it's allowing that any property that the government files a petition about, they can then seize pending disposition of that petition.
And we can hear more about it. Maybe it's a semantic difference. It just doesn't seem to me that it's expanding the description of what can be seized, but rather, assuming the law enforcement authorities are acting in good faith, they believe that under the law they can seize property, but in the interim, until they can get the court to recognize that, the property could be absconded with, and so they're temporarily securing it.
And if what you just said is what this provision said, we would be happy with it and would drop our objection to it. I don't think that it clearly says that. And that's why we have an objection to that provision.
Okay, sounds good, thank you.
I saw that as temporarily protecting the $100,000,
Right.
because obviously it can go very quickly if they don't.
From our perspective, if that was addressing property that was already subject to legal seizure, then it would already be covered under subsection B, which is the section that deals with property that's already been legally seized. This is a new section, and when you add new law, you're almost always creating something different in the law. So from our perspective, just by the very fact that subsection B deals with what's already legally seized and subsection C deals with something else, it's dealing with something beyond what's already legal seizure. So in the next section,
We'll flag that. Next section.
So in the next section, which is on page 5, section 4242A, this just creates a disparity that we have a concern about, which is that when we talk about prompt post-seizure proceedings, a criminal defendant is necessarily going to have a public defender to represent them in those proceedings, because if this was being put under the criminal statutes, then where there's no public defender assigned under the civil forfeiture statutes currently, there will be under the criminal statutes. However, that would only go to the defendant. So you create this weird disparity where a defendant, an owner, or a co-owner may petition the court for post-seizure hearing and ultimately for release of that property, but only the defendant has a court-assigned lawyer for that, and a co-owner or regular user or owner who's not a defendant is stuck trying to do that pro se, which is a very, very difficult task. And frankly, whenever we say that people have to do stuff pro se in court, you ultimately wind up with most people just simply not doing it. They just don't even attempt to avail themselves of their rights if the only way they can pursue those rights is to petition the court pro se. And I'd say that's particularly true in the context of the criminal courts. Other parts of our courts are friendlier to pro se clients because they deal with a lot more pro se litigants. So, for example, the domestic docket has programs just to train pro se litigants in how the court works and how to pursue their case. There's nothing like that in the criminal division because almost everything is handled by attorneys. This would be creating a little exception where there would be, for just a few people, no attorneys there to assist them. And that would really, frankly, probably leave a lot of them not really being able to avail themselves of these rights, even though these rights are being enshrined in statute. Let's see. Then this is going to come up in a few other places in the bill, but on the next page, page 6 in section 4243, we have a real lot of concerns about the idea of forfeiture being written into the statute as a criminal sanction. When you say that something's a criminal sanction, what you're really saying is it's part of the sentence for the offense. It is something that the court will consider when the court is sentencing the person. And our problem with that is that if what we're saying is that the courts can consider forfeiture as part of the sentence, then we're saying that people who have something to forfeit are necessarily going to have an advantage at sentencing over people who don't. So for example, if you have two people and they're both charged with the same offense, say it's sale of heroin, since we're talking about drug forfeiture, and if one of those people has a house worth $250,000 to forfeit and the other person has nothing, just has, they were just selling heroin out of their pocket. If this is considered part of the criminal sanction, then the person who has the $250,000 house to forfeit has a very good case to make that they should be entitled to a lesser incarcerative sentence or a lesser probationary sentence or a lesser supervisory sentence because they've already been sanctioned by having their house forfeited. So this really creates an inequity when we call it a sanction, and that's a change from current law. In current law, we don't ever refer to judicial forfeitures as criminal sanctions, and we don't ever suggest that they should be, taken into account as part of sentencing and that it should be weighed in among incarcerative sentences and, supervisory sentences as part of the criminal sentence, and therefore really turning criminal sentencing into a financial, into something where people with financial resources have a financial advantage. We also just have a concern about it because forfeiture is not individualized. You don't decide whether property should be forfeited based on the culpability of the defendant. And so when you say that something's part of criminal sanctioning, you're really removing the individualized aspect of sentencing. Criminal sentencing is supposed to be entirely individualized to the circumstances and culpability of the defendant. And if you're saying that all property that's forfeitable must be forfeited, which is what this bill says, then you're not individualizing it to the circumstances of the defendant. And if you say that you're going to individualize it to the circumstances of the defendant and say, this person has a $250,000 house that's an instrumentality of crime, but we think that this person was not very culpable, doesn't warrant a large sentence, and therefore we're not going to forfeit the house, then you're really not treating it as forfeitable property at all, because the idea of forfeitable property is that the possessor of it, the owner of it, doesn't actually have a legitimate interest in it because it was either property that they gained through criminal activity or that it was itself an instrument of criminal activity. So if the idea is that they're not supposed to have any legitimate interest in it anyway, then why should it benefit them at sentencing that they forfeited it? So we have a lot of concerns about this idea of it being part of a criminal sanction, and you'll see that reflected in other places in the bill as well. On the next page, page 7, it provides that let's see, what was it with this? This part was just unclear. The notice that's provided that says that the state will provide notice within 30 days of its determination that it will seek forfeiture. We just think that that should be a much more clear time frame. That should somehow be tied not to the state's decision-making process, but to the initiation of a case, something concrete, something so that people know when that, if we're going to have this be part of the criminal process, it should function like part of the criminal process, and people should be able to really clearly see when they're going to receive notice, and if notice hasn't been received by a particular point, then that they don't have to worry about receiving that notice. If you say that people are getting notice based on when there's a decision-making process, then you're really not providing any clarity around notice at all. We think we also have concerns. We skip ahead a few more pages, and that's on page 11. Subsection B is exceptions to the conviction requirement. So this bill would require that people be convicted of an offense prior to there being any forfeiture of their property. Property can be seized prior to their conviction, but not forfeited until their conviction, with a handful of exceptions. We have a concern about one of those exceptions, which is the exception for death. If this is going to be part of the criminal process, it should follow normal criminal rules. One of the fundamental common law principles of criminal law is the doctrine of abatement, which is that if you're involved in a criminal proceeding and you die while that proceeding is pending, that you are acquitted. You are given the benefit as if you were innocent, and that's because you never had the opportunity to contest it. People's property, just like anything else, shouldn't be taken away from them without giving them the ability to contest it, and that should be true whether they've lost the ability to contest it because they died or for some other reason. And so we feel that that should just simply follow normal criminal process. In normal criminal process, if you die while your case is pending, you are innocent and you are not subject to any of the criminal sanctions that are associated with that offense. That should also be true of this. You should not be subject to criminal sanctions if you died while your case was pending. So we do have concerns about that. We think that, it's again, we appreciate the idea of bringing this process into the criminal court system, which we think would provide it with more regularity and more process. But then we keep seeing these parts of where we're kind of creating exceptions and saying, well, we want it in the criminal justice system, but we don't want this part of it. We want it in the criminal justice system, but we want to be able to seize stuff in ways that's sort of outside of the normal criminal process. And that's where we get these concerns that what this really is sort of taking the worst parts of the criminal system and the worst parts of the civil system and combining them together. And if this is going to be in the criminal system, it should follow the criminal rules and the doctrine of abatement should apply. We also have a concern on page 12. At the bottom, it provides that the defendant has the burden of establishing forfeiture is unconstitutionally excessive. That's what the law is under federal law. That's not the law under Article 11. And the Vermont Supreme Court has not ruled on this issue under Article 11. And we think it would be premature to be saying in statute that it would be the defendant's burden to prove unconstitutionality under the state, because we don't know where that burden lies under the state constitution. But I would say that overall, under the Vermont Constitution, burdens of proof in situations like that are generally put on the government. And I think by comparison, the closest thing to compare it to would probably be restitution, because that's that's another place where the government is seizing personal property because of someone's conviction for a criminal offense. And in that case, the burden is on the government at every step of the game. It's on the government to prove the need for restitution. It's on the government to prove the amount of restitution. It's on the government to prove that the amount of restitution is not excessive. We think it's incongruous to say that the defendant should have the burden of proving that restitution or that forfeiture is excessive. And that honestly, given the disparity between, or the fact that the state has been, the state constitution has been silent on the burden so far, we think that the statute should be silent as well and leave it up to the courts to figure out who should have the burden and not put it in statute.
Okay.
So on pages 14 and 15, we're very happy with these proposals to include hearings for lien holders or innocent owners. We think that's a good provision, and we think that really provides some protections that are really important that we don't have in law currently. But we do have a concern on the next page, on page 16, where it talks about knowledge. So this is in subsection 4, about halfway through that paragraph. It's the phrase that says, or have actual knowledge that the property was being or was intended to be used in a manner that would subject the property to forfeiture. Our concern about that is that it essentially turns people's family members and innocent owners into police, putting a role on them that they didn't ask for and that they don't have in any other context. So we don't say to people in Vermont, if you know about people selling drugs, you need to turn that in. If you know that your neighbors are selling drugs, you need to turn that in. If you know that your family members are selling drugs, you need to turn that in. But what this provision says is that if your family members are selling drugs in your house, and that's the only place you have to live, and those are the family members that support you and care for you, but you don't turn them in, then you're not going to have any right to turn around and say, if they get arrested and the house is subject to forfeiture, you're not going to have the right to try to say, I live there and I wasn't selling any drugs and I want to be able to continue to live there. They're saying that if you even had knowledge that there was drug activity going on in that house, then you don't have the right to petition as an innocent owner. And guess what? Most of the innocent owners we're talking about have knowledge that illegal activity is taking place. You know, most of the people that I've represented who have been selling drugs or possessing large quantities of drugs, the people in their life have known that, but that doesn't make them any less innocent. You know, a lot of these are people who don't have the ability to just, you know, up and pack up and move out, and they have families together and they have relationships together, and their lives are massively intertwined, and they own things together. And it, you know, for us to create in this section essentially a community policing ordinance, something that says the property that you depend on for subsistence will be subject to being taken away if you knew that that property was used in whole or in part for drug activities, or that it was purchased with the proceeds from drug activities. I mean, that could be anything. That could be the clothes that children wear. That could be the cars that people drive. It could be really the stuff that people need to get by in their day-to-day life. And we would be saying that you don't have the opportunity to simply go to court and say, I really need that stuff. I need that stuff to get by. You don't even have the opportunity to make that argument as if you knew that that stuff was being used in connection with drugs. And we think that that's really inappropriate. The next provision on page 17 has to do with appeals, and we have concerns about that too. That says that the defendant can appeal the criminal division's decision. But we just got through saying that there's hearings for lien holders, innocent co-owners, innocent owners, co-owners, and regular property users. And this doesn't give them any rights to appeal. And honestly, if you create a right and don't create the ability for somebody to appeal a bad decision, so you create the right for them to have the hearing, but don't give them the right to appeal the bad decision, you're just creating arbitrariness, and you're setting up a situation where you're going to have law that is, you know, enforced in very disparate ways around the state, because the way that we get regularity in our law in this state is through the appeals process. You know, we have very disparate decisions coming out of different courts, and then those decisions get appealed and the Supreme Court rules, and that sort of tells the whole state, here's how you rule. And there's going to be particular issues that are going to come up around, non-defendant, the forfeiture of property that non-defendants have interest in. But if only defendants can appeal those decisions, we're never going to get any regularity around those decisions. We have the same sorts of concerns around the changes that are made in the next section, 4245, which addresses the petitions for, what did they call it? Petitions for remediation or mitigation to the state's attorney. And that's, again, a situation where current law allows those petitions to be sent to the judge. That allows for there to be some transparency in the process. If the judge has to make a decision, then the judge has to make a decision in a particular way. And if you don't like the outcome of that decision, you can appeal it. If the decision is made by the state's attorney, you can't make them make that decision in any particular way. And there's no way to appeal that decision, because we can appeal the decisions of courts, but not the decisions of state's attorneys. So this creates a right, but it doesn't create any remedy for that right. And honestly, a right without a remedy is kind of, when you create a right that you can't enforce, you end up with, again, real disparate practice around the state, and with people getting really different outcomes just depending on, what county they're in and who they're dealing with. I think that's all we have comments on. I would say the same as Evan said, that, we do have a lot of interest in this bill. We know there's a lot of moving parts to this bill. It's a big and complicated bill, and we expect that there will be a lot of changes made to it. We would ask that we get the opportunity to come back and comment on those changes, because as you've heard, our concerns about this bill are procedural, and they have to do with really, sort of the mechanics of it. And so, even small changes are going to have a lot to do with our position on this bill. So we would just ask that if changes are made, that we have the opportunity to respond to them.
Sure. Do you have a copy of your testimony?
No, Senator, that was just from notes.
Okay.
I mean,
I was just trying to follow all your concerns in the various places, and I'm sure I missed one or two.
I think then,
So,
Senator, if I have a chance this weekend, I'll try to type up some bullet points and I can send those along.
yeah, if you could do that, that would be helpful.
And Senator Steers, if, I can also follow up with Mr. Paul on his concerns.
Okay.
I'm doing my best to keep it tally, but, I'm happy to consult with him if the committee would like.
Here,
Did he, did,
I'm going to apologize to some of the other witnesses. I've just been, I think, are we ending at 11 or
Yeah.
11:30?
11?
You know, we don't get enough warning if we set an agenda. It's really difficult to continually do this.
That was my fault that we're there.
Yeah, well, it's just kind of,
Oh, is the floor 11 today?
No, there's a caucus of the whole.
well, yes, we're on the floor to look for all
Okay.
intent
Yeah.
purposes.
Yes.
Oh, I didn't know that.
So I apologize to anybody, and hopefully you'll be able to come back the next time we schedule this. But I do want to hear from anyone who's not able to come back at a later date. If anybody's in that position, let me know right now. If not, I'll go to Roger Mark. And committee, we had scheduled a break, but since we're quitting at
Yeah.
11, I just wish we'd get better notice of changes in committee time.
No one told me.
Pardon me?
No one told me or anyone.
That, I will take full responsibility for that. We talked about, I had told leadership and Secretary Booker that we were going to have we wanted to have a caucus of the whole, and so we've been talking about it for a period of time, but everybody should have gotten a notice a week ago. I mean, should have,
Sheriff,
if we had.
thanks for joining us again.
Yes, good morning, Chairman Sears and everybody in the committee, and thanks for having me. Roger Mark, Lamoille County Sheriff. And just by way of background, I'm really particularly going to be focused on the drug narcotics enforcement aspect of this bill. And not to be redundant, but I have spent 12 years with a Drug Enforcement Administration task force, and I'm particularly interested in the federal aspect of this. So I've written my testimony here, or I have notes, and I'll just go through it to get through it because I know we're crunched for time. I've been involved in the supervision of narcotics enforcement since the 1980s, and all but 5 of those years were in Vermont. I've seen the escalation of drug trafficking and violence associated with drug trafficking organizations from out of state, where in 2021, over 200 people lost their lives to opioid overdoses. And law enforcement is already shorthanded, predominantly with drug-related crime and public health issues stemming from substance use disorder. In 2021, overdose deaths in my county has doubled, and they lead the state in per capita basis during that time. I've mentioned the shortage of law enforcement officers in the state, and every department is short, and some agencies are down to the bare minimum for shift coverage. Overtime work drives up the cost of the enforcement, and given the economy, there's continued pressure on taxpayers. The focus of my testimony today is predominantly on the section 4248A, the limitation of federal adoption. The ability to access federal adoption by state and local law enforcement is critical to drug enforcement efforts here in Vermont. It helps municipalities pay for investigators and other costs associated with the investigations. I'll attempt to break down how a seizure occurs, and I hope it'll be helpful for the committee to understand the great lengths that the federal authorities go to assure that people's rights aren't violated. But when a law enforcement officer stops a vehicle for a legitimate reason, it's not uncommon to see drug paraphernalia such as syringes, glassine envelopes used in the packaging of drugs, weapons, or cash in plain sight for the officer to see. The seizure may occur after the plain sight observation or after a search warrant is executed. Seizures also occur after more lengthy investigations of drug trafficking and the federal drug law enforcement and judicial system become involved. This usually involves much larger quantities of drugs and illegally obtained assets. The federal system in Vermont does allow for due diligence, and there's an administrative mechanism for the seizure of unclaimed suspected drug proceeds, where the owner refuses to recognize themselves or identify themselves. And it's not uncommon for suspects in drug trafficking to deny ownership of money or to assist authorities with who the owner is. This is rough. This is roughly the path that seized assets take in both administrative seizure and criminal seizures with the U.S. Attorney's Office. Administrative seizure may occur with either the DEA or the FBI or something like that, and it would look something like this. A law enforcement agency seizes cash in a legitimate stop, and it might be cash, it might be a vehicle, but not real estate. The Burlington resident office of the DEA would be contacted, and they would review the circumstances behind the seizure. If it fits their criteria, they take custody of the asset and they try to identify the owner, which is a common theme throughout the process. DEA Burlington consults with DEA New England Field Division, which is their headquarters, where their counsel reviews the seizure. And if they agree that the case has merits, then and there is still no owner identified, then they push it up to DEA headquarters in Washington, where their chief counsel's office takes a look at it and assesses the merits of the case. There's attempts to, there's many attempts to publish and try to determine the ownership throughout the process. And if they do find an owner, then those folks have a whole separate track that they can follow to file a claim. If the DEA headquarters in Washington deem that it's seizable and they deem it forfeited, then they are the ones who make a determination as to how those assets are shared with the different agencies involved in the investigation. In a criminal case where it goes to the U.S. Attorney's Office, if an asset is seized, the U.S. Attorney's Office may look at it and it would go to trial just like a real person would if it gets that far into the process. So a local agency would contact federal agency like the FBI or the DEA or HSI or one of the alphabet soup agencies there, and they would see if the case fits their criteria for adoption, and they would essentially may take over the investigation. The U.S. Attorney's Office would review the case when it was presented to them by that federal agency, and if it passes muster, bring it before a grand jury for indictment or no bill, true bill or no bill. The forfeiture case would then, after that, if it's indicted, go through the regular process right up to either a jury trial or some kind of resolution before then. And in the case of a conviction, it would be an appeal process. Another very extensive throughout the process, or after that process, they would be published again. And I'm told by somebody who spoke with the U.S. Marshal's office that they think that they might use like the Wall Street Journal, and they make real efforts to try to find the owners if they have not been involved or have not been identified. Often there's a dual track where you have a defendant in a case, and they're on their own separate track in the process. So this is rough, and there's a lot of experts I see on my screen here, and I simply want to point out and illustrate the current efforts that are made to ensure that innocent third party does not lose what's theirs. Federal judges and our magistrate in Vermont have extensive experience with our judicial system, with our state judicial system. Some of them, Judge Rice was a state judge. Judge Sessions was a well-known defense attorney. So I think that they're Vermonters, and they're very conscientious of the great power that they have. Federal system works very hard to protect the rights of the innocent owners of seized assets. And the state system is not utilized, as been pointed out by Evan Meenan, by law enforcement here in the state for the most part, because it's unwieldy and the courts are very overloaded right now. And the proposed bill, in my opinion, will add to the backlog if it's our only option available. The state local law enforcement should be allowed the option of seizing cash well less than $25,000 for federal forfeiture. Large amounts of cash are not entrusted by out-of-state drug trafficking organizations to drug users who have been enslaved. These people often are forced to transport opioids and other addictive, dangerous drugs from the out-of-state drug trafficking organizations to locations to our local communities. The drug trafficking organizations make those suffering from substance use disorder the targets by having them take the significant risk of transporting drugs to Vermont. They also transport smaller amounts of cash back to the state, perhaps once, perhaps twice, perhaps several times a week. Drug trafficking organizations' business lose when they are stopped in their seizures, so they keep that to a minimum. Seizing smaller amounts of cash may allow for a federal seizure, but it does not always result in instant federal criminal case against the drug trafficking organizations. So investigations of this nature take time and patience. When I worked for the DEA task forces, investigations could go on from 1 year to 2 years or more, with many small seizures, eventually leading us to the heads of the drug trafficking organizations that are pushing this poison. It's important to know that many of the lower than $25,000 seizures did not necessarily result in an immediate arrest. This was allowed for the continuance of the case while safeguarding the sources of information and the undercover personnel. So in closing, I'd like to reinforce the following. Law enforcement in this state has to continue to have the ability to leverage the federal adoption system with seized amounts under $25,000. The state and local municipalities should be allowed to participate in the federal adoption program for seized assets in an effort to help sustain law enforcement operations throughout the state. State and law enforcement should continue to adhere to federal laws and rules concerning asset seizure and forfeiture while under the guidance and direction of the Department of Justice and our federal courts. And lastly, seized assets in Vermont have not amounted to a great deal of money in the last few years. I have a person assigned to the DEA task force. We have not received any money in the last 2 years. All we're looking for is to help pay for that capability because we're getting flooded with so many of these out-of-state drug trafficking organizations right now, and there's just simply not enough personnel in this state to investigate these cases, especially when you match them up to the overdoses that are taking place. So with that, I'll end, and I would hope that you really reconsider that last section and consider just eliminating it altogether. Thank you.
Can you send a copy of your testimony to Peggy?
Yes, I will. I'll clean it up and I'll get it to you. Yes.
Great, that would be helpful.
One thing, Senator, I didn't mention, I'll just show this manual here. These are the rules of what you can use, what the feds say that you can use seized asset money for and what you cannot. So just, I just want the committee to know that such a manual exists and they and we take it very seriously.
Appreciate that. Any questions for Sheriff Marcoux?
Nothing.
I think you're very clear, and since you haven't received any money in over 2 years from the feds, if this were to become law, what do you think would happen in Vermont? Would we still use the federal system, or would we go to the Vermont?
Well, it's two, there's several little pieces to it. One is nothing is saying that we cannot work in concert with the federal authorities. I think that that's pretty clear. However, I can't participate and I can't have that resource of having a deputy trained by them and working with their DEA task force if I can't pay for that individual. Right now, because of COVID and everything, that really, I think that COVID really had a lot to do with, well, basically the entire asset forfeiture unit with the DEA in Washington didn't work during COVID. So they're backlogged, I don't know how many thousands of cases. So to give you an idea what that means to a community, my person is trained and he works under the guidance of DEA. I have that person working with other surrounding departments here, and he is coordinating the efforts of these departments. And if our little community is getting this influx of out-of-state drug trafficking, and we just lost a 17-year-old kid to an overdose here probably 3-4 weeks ago, I'm sure that other communities are. We have the ability right now, with the way the system is working, to sort of take control of our own community here and take the responsibility of working on some of these cases to try to improve the quality of life for our community. And Senator Sears, you know this of me. I also believe in the treatment aspect and the partnership with all of the other folks. And I'm heavily involved in Jenna's Promise. But we have a responsibility as law enforcement is to protect the community from the very baddest of the baddest. And we need all the resources we can get to do that. And I just don't see what the issue is or what has happened here in Vermont that that has triggered this notion that we need, we shouldn't have the ability to participate in the asset forfeiture program.
Any other questions? Thank you all very much, and my sincere apologies to everybody that we didn't get to this morning. We will reschedule next Friday.
You want to do that, so you want, which one do you want bigger, 534 or 629?
Which one's 5?
Ceiling.
So we'll put that in Marcia.
Yeah.
Okay.
Okay, we're going to adjourn.
Yes.
And go upstairs. Listen